And we're speaking with
Katrina Morrison.
and Katrina. Why are you here tonight at Planning and Zoning?
I was asked by an individual in Little River to look at a current plan being brought for rezoning. I am not a zoning person. I am not an attorney. I'm actually an arbiter. But because of a previous issue where I am currently involved in a lawsuit against Horry County Planning Commission, and the Horry County Council regarding the resolution being brought 51/2021 for Cohina Harbor development, during the Planning Commission phase of that, I say resolution, I forget, is it an ordinance when it starts in Planning Commission? I'm not sure, but it goes to the Planning Commission. It was presented at the workshop for Horry County Planning, and they neglected to mention this consent order. The consent order was brought about in 2006, and Horry County Council and the developer entered into a consent agreement, which was approved by a court. Some say that a consent order is not, certainly not an ordinance, as was brought up by George Redmond and falsely said to the Planning Commission. But a consent order is where a court does not tell you what to do. Two parties come together, they make an agreement, and the court signs off on it based on the fairness of the consent. So in 2006, a judge signed off with Cohina Harbor Resorts, LLC.
And Cohina Harbor Resorts is where they're developing?
Well, Cohina Harbor is the harbor that is in Little River. It's man-made, so it's called Cohina Harbor. So Cohina Harbor Resorts was an entity, an LLC, and they went bankrupt in 2013. So now the owner is CHF, which, by the way, stands for Cohina Harbor Resort. However, it is a new and completely different entity than Cohina Harbor Resorts, LLC, which owned it originally.
And for our viewers, what are they trying to build? What are the developers trying to build?
Well, on one hand, they're saying nothing. On the other hand, they submitted a plan of, I believe, a 12-story building, car parks, 705 car spaces, 335 approximately units of living space. It's not necessarily clear whether that is permanent condos, is it transient? No one's been actually clear, but they have submitted the plans for rezoning, but are saying they never intend to build. And that doesn't make a lot of sense, and I don't know any developer who would spend the money to have plans written up, and as we were told by Felix Pitts from G3 Engineering, an enormous amount of money has been spent by the developer to invest in this project. Well, if that's the truth, why then are they at the Planning Commission saying this is never actually going to come to fruition? Well, that doesn't make a lot of sense. So the rezoning they were looking for, the current rezoning would, because of it's my understanding now, Little River overlay limits a 60-foot maximum. And this consent order from 2006 would have allowed them to go to 120 feet based on the consent order. So if they had simply made a planning, they would not have needed to rezone. They could have submitted a planning application with a special consideration based on a court order or a consent order that, let's say, the county attorney signed off on. It was a legitimate order, and the county attorney would sign off. However, during the Planning Commission meeting on May 6th, the county attorney's representative, I don't believe it was the county attorney himself, but I believe his representative was saying, number one, the county found that the consent order was invalid, that too much time had passed. Now, that wasn't a good argument to make, in my opinion. First of all, it's an argument that never should have been made in a Planning Commission meeting. The Planning Commission are not attorneys. They are not an adjudicating body for legal issues. They are a technical assessment, as you know, Chairman Steve Neves had pointed out numerous times, that their job was technical assessment. And after listening to John, I don't know John's last name, I meant to mention this to the Planning Commission tonight, the Planning Commission at that point was being held, in my opinion, in a very informal manner because no one knew who was speaking. Although George Redmond would introduce himself and initially Felix Pitts was introduced, this is not like a county council meeting where it's videotaped. It's audio taped, so if you're not a party to the room or you don't know the members of the commission, you don't know who's speaking. And again, tonight, I wish I had mentioned this because it's extremely important that if a council member is speaking, you see and know who that is. Or if you can't see them, they should say, this is, Chairman Brown or Commissioner Brown has something to say. Then I would know it was Chairman Brown making a point. But unfortunately, in these meetings, you don't really know. So I'm just mentioning that because
Chairman Brown is a developer, correct? Charlie Brown you're speaking of?
I don't know. I noticed there is.
Yeah, he's a developer, I understand, but continue.
I just say that because at the end, now I'm talking about the Cohina Harbor issue, at the end of the May 6th meeting and the discussion surrounding this consent order, it was Mr. Brown, someone else told me, I was listening to the autos and transcribing, and I was informed it was Mr. Brown who said, we were forced by court order, there's a consent order, because of the consent order we have to vote yes, why are we wasting all this time if we're required to say yes? And I don't believe for one second that Mr. Brown ever read that consent order, because if he had, the only thing the consent order said was that Cohina Harbor Resorts LLC was given permission to submit a proposal with a height maximum at 120. That did not give them planning permission. It did not give them rezoning permission. It didn't give them a go-ahead by anybody, although Mr. Pitts and Mr. Redmond alluded throughout the whole time that in 2006 they had the go-ahead. They were already ready to proceed, and that was not true because formal planning had never been even applied for. If that had been done, they would have had this transfer. It would have transferred with the property when they sold it, making the property very valuable, by the way. If in 2006 this was actual rezoning or planning permission, those things never happened. This was a consent order between two parties, and it doesn't transfer. It is not like once you've been issued planning permission. This was simply a consent order. Why the county attorney never addressed this properly before the meeting, I'm not sure. Why did George Redmond say directly to the commission, planning commission, that the week before when they were at the workshop, he accidentally forgot to bring this up? Now, that might be true. God love him. I don't know the man. I'm just saying that it was the only thing discussed the entire night. We never really got to the technical assessment, although John, who is a staff member under Steve Neves, who Steve Neves clearly asked, how did the technical assessment go? Does this fit the comprehensive 2040 plan? He was told no. He was told no on 2 occasions. Mr. Neves asked why. After listening to the presentation, it was pretty self-evident, in my own opinion. Some things speak for themselves. And this man, John, said overusage does not fit the 2040 comprehensive plan. He did not say because it's 120 feet. He did not say because it's this developer. He did not say because of a consent order. He said it does not fit the comprehensive 2040 plan. It failed. However, the entire room, with the exception of one person, Pam
Dawson, correct?
I believe so. She voted no. I haven't had the opportunity to ask her why, but she clearly wasn't convinced, like the entire rest of the room, that there was a consent order forcing her to vote no, to vote yes. And after going back and, I went to the county council when this was put forth to the county council. I went and spoke publicly. The issues are never ending. Environmental, traffic, the rainwater runoff. There's so many issues, the dredging, the amount of silt, the problems we already have with flooding as a result of the other side of the highway being overdeveloped at this point. So
now, is the property, you say it's a man-made property,
harbor.
Right? It's a man-made harbor. Is the property considered wetlands?
No, it's not, I don't know if it's wetlands, but what it is, I have to think, the watershed. Okay, so in 2018 and 19, there was a multi-jurisdictional massive study for the environment for the shellfishing. All of these jurisdictions agreed, or a county in particular in 2019 did pass a resolution guaranteeing that they were not going to interfere with this watershed, that they were going to do everything that they could to protect the ongoing efforts for the shellfishing. And that watershed in question throughout the entire I think it's called the Hogs Head Inlet Environmental Study, if you look it up. That watershed begins at Cohina Harbor. It begins at this very harbor that they're looking and talking, and whether they intend or don't intend to do it, they have submitted a rezoning application with the intention of a 12-story building, multiple car parks, and massive influx of people on top of something that is drastically fragile when it comes to the environment, the ecosystem, and what is currently they're trying to fix.
So for our viewers, what Mr. Pitts is proposing is a high-rise.
Yes, they're absolutely proposing a high-rise on the corner, and I say the corner, as I've been told by South Carolina DOT, it's actually 350 feet from the corner, which is all good and fine. However, that corner, I've done these studies, I've looked into this. I'm not a member of the Planning Commission, but I do have an obligation as a human being and a citizen to look into matters when I don't believe them. So the corner of 17 and 90 was intended for 12 to 14,000 cars per day. Maximum 16,000 cars would be a very high volume. As of 2019, the actual figures from South Carolina Department of Transportation are 41,600 per day at that intersection. 350 feet, as PennDOT, as South Carolina DOT has told me, 350 feet from the intersection is where they'd like to put up a high-rise. There is no possibility that that intersection and the surrounding area, which is one of the highest accident areas in that little area, that is it, right there. Last Wednesday, there was an accident on 17 at about 2:30 in the day. It closed down Highway 17. That traffic backed up into North Myrtle Beach. I don't know what the intersection, but if I said by Publix, it was backed up 9 into Longs because of one accident that occurred on Route 17 at Cohina Harbor, just past where they're talking about having this build. There is no way that that area can support a high-rise of any kind.
Are there currently any other high-rises at Coquina Harbor?
None.
So this is unprecedented.
Unprecedented, unwanted. The public outrage over this was and George Redmond brought this up himself. It was massive and clear in 2005. The public did not want it. The very same public who lives there, and not just, I live in Lighthouse Point. It's Lighthouse Point, it's Eastport, it's Cohina Harbor, it's everyone around. You have on the other side of the street, you have River Hills, you have Heather Glen, Heather Lakes. Eastport is such a big community as well. We're not just talking about a few homes. We're talking of thousands of homes and thousands of people on that road who are not coming for vacation. We live here all the time, and this is directly going to affect our way of life every day. It has nothing to do with the height of it. It has to do, could you imagine the construction trucks? The bigger issue for me, the bulkhead that's there that protects the head of the face of the harbor before 17, how far would you have to dig down and put steel into the ground to put up 12 stories? You're not putting that on a slab. And even if you put it on a slab, half of what's beneath that ground is unstable to begin with, and they still would have to fill to get up to just sea level. Just to get up to basic ground, they still have to keep filling. And having said that, they were happy to take the sediment when it's pulled out from dredging, which, by the way, doesn't have to happen for another 7 years. And again, during the presentation to the Planning Commission, it was told to the Planning Commission that all of the homeowners, they were engaging as really good neighbors, as Mr. Redmond and Mr. Felix Pitts were saying. That was blatantly untrue. They did not engage with a single homeowners association, not one. They engaged with the dredging. It's a joint venture for dredging, and that joint venture has no authority to speak for any of the homeowners. No one in any one of these homeowners association is in support of this project. So
Say that again? Say that again.
No one. So there are 6 homeowners associations.
And not one supports this?
No one.
Okay, so it goes to Horry County Council. Did they pass this?
The second vote passed, the third vote is yet to happen.
Okay, and so let me ask you this. How have you responded? What's the response been? What are you currently doing?
So I have, as of last Wednesday, filed suit against Horry County Council, and Horry County Planning Commission. I have asked that that no further action be taken by the council or any other part of the county in regards to this matter until such time it can be investigated for false misrepresentations being made at the Planning Commission, for the breach of separation of powers, which is completely unconstitutional. The legal matters were adjudicated during a Planning Commission meeting, and they had no authority to adjudicate a legal matter that should have been handled by the county attorney's office prior to this ever coming to the Planning Commission. You cannot use the Planning Commission to settle a lawsuit, and that is exactly what George Redmond said to the commission when he came in and said, we're here to settle a lawsuit from 2006. No, we don't settle lawsuits in Planning Commission meetings. We settle them in courts of law. And so... Can I ask,
has any of the council members or the planning and zoning members been served yet?
Everyone has been served through the county attorney's office. The county attorney represents the county. He represents the county council. He represents the Planning Commission, as I'm clear to understand now. I don't see how the county attorney, as he is a part to the suit and a defendant, as a result of the suit, I am patiently waiting. I've asked for an injunction. I am waiting on a date for a motion hearing. Not only did I ask for the injunction to prevent any further action and review for constitutional issues, I asked that Attorney DeSabato be removed from council, as he himself fraudulently gave information to the public and to his fellow council members. He very clearly stated in the meeting that his fellow council members would be held in contempt of court if they did not vote yes to this. There is no truth in that statement. And as an attorney and as a professional who said he had special skill and knowledge about property law, he would have known this did not even have a transferable right. It was simply a consent order. And no one should have been told that this forced a vote or compelled anyone to vote one way or the other.
Now, council meets this coming Tuesday. Are they scheduled to vote on this matter then?
I have not seen the agenda. I will obviously be in attendance at the meeting. I have not signed up. Now, although it's an unwritten law, if you didn't know this, you can't speak at every county council meeting. They get tired of listening to you, and out of a degree of respect, I would not expect to speak at every county council meeting. However, I intend on listing myself. I can only hope that Pat puts me on to speak, because of course you're only, as the public on an ordinance, you're only allowed to speak one time at the second reading. There's no other public debate. Therefore, it doesn't seem like really due process is happening, because the developer can come back and speak anytime he wants. If a question is going to be asked, the developer has to be there to answer. But if I have a question like, excuse me, Attorney DeSabato, why did you tell everybody things that weren't entirely factual? I would like to be able to answer that question. I would like an answer to that question. I had to file a suit. That suit cost me money. It's not for free. I had to pay the fees to file the suit and copy everybody and do all my duty to file the suit. I expect an answer.
Are you intending to try this in the 15th Circuit Court here in Conway?
I have submitted it into the 15th Circuit Court. As I said, I'm waiting for a date. I have not received a date for my motion that I filed, nor obviously a date for the suit itself. I don't expect to hear anything too quickly. However, if it turns out that they send this back to me, there's no case to answer, which could happen. The court may find that to be. I will certainly be taking it to Columbia for judicial review, as this is an administrative body. Planning Commission should not be interfered with by any court, and any attorney bringing such a notion into a Planning Commission meeting should be sanctioned and should not be allowed to come back.
And one last question. Do your neighbors in River Hills and Eastport and Heather Glen, do they support you in this suit?
I can't speak for all of those communities. I don't want to get anybody mad at me. I can speak for my homeowners association, who have been very supportive of my efforts here. I can speak for the surrounding homeowners associations around Cohina Harbor, who absolutely do not find this to be a good idea or for the benefit of the people who live on the harbor. I think petitions were filed. I think petitions were given in. I think there were multiple people including a South Carolina engineer who spoke at the Planning Commission meeting himself with extremely great reservations and questions, which were never answered. So I can only say the people surrounding the harbor that I come in contact with constantly, and I met with a great deal of people from other places last weekend in a public meeting I held just to inform people what this suit is. I'm not suing personally. I mean, I filed a suit. It says Katrina Morrison, it says William Neely, it says Annette Highland, and all others in Horry County, all citizens of Horry County, those who are affected by these actions. So I don't think it's considered a class action. It is me speaking for any citizen in Horry County who feels this is not right. These are constitutional issues. It's not just a matter of a car accident where there are two people involved. This involves the whole county. This involves the people who we trust in the, as I said in the Planning Commission meeting tonight, we put our trust in these people. You know, I take my car to the mechanic and he does my brakes. When I drive away, I know my brakes work. At least I hope they do, because he's the guy who knows how to do it. I trust the Planning Commission knows what they're doing. And it was shocking this week to find out that there's no environmental study needed when you're building on a harbor. They don't ask for that when they're asking for rezoning. When this particular resolution tonight, another member of the community called me and said, please look at this. And I looked and I said, wait a minute. We don't even know if there are wetlands. We have a map that it's the Fish and Game Commission say, yeah, there's 12 acres of wetlands here. But we have a developer who's saying, no, only 2.6 of it is wetlands. And I called, I spoke to Lee, who is at the Planning Commission, and I said, how could there be such a discrepancy? And she said, oh, Fish and Wildlife is not accurate. Okay, well, the rest of the country relies on a federal agency to tell us this, but in Horry County, we don't rely on that as accurate, and we'd rather take a developer's word that says 2.6. I find that discrepancy too far. If it was 1 or 2 acres, if it was 10% difference, that would be one thing. But this map clearly laid over on the developer's application showed 90% of the land they were looking to develop was wetlands. And based on the 2040 comprehensive plan, it's in something that has conservation attached to the map. So I'm saying, okay, well, if we have a particular part of the map that says conservation, and we just have to do rezoning, we don't have to prove that it's not wetlands, we don't have to prove we're not harming anything, we just have to say, the developer just has to come and say, well, we don't think it is, we can estimate. And no one questions that estimation. So who is the due diligence, the due diligence of these applications falls on who? We have to trust the developers are telling you the truth, but that's like trusting a car salesman to sell you a good car. We all know we should be skeptical. Well, I expect that the Planning Commission, I'm hoping, is going to be a little more skeptical now when I point out that this is 90% wetlands and they're saying it's less than a quarter or less than an eighth. That's too big of a discrepancy. Why can we not ask for a clear report from the Army Corps of Engineers to say whether it is wetlands or it isn't? And of all days today, how many inches of rain did we get during a storm? The runoff was astronomical into Mullet Creek over there because of Heather Glen, because of other lakes. There's a massive development, and there's another development now on the other side of this 14-acre parcel they want to develop. Well, that is the only grass-covered roots that are left in that area. And now they're saying, well, it's not really wetlands, it's only, an eighth might be wetlands. But they're guessing. So when are we going to start looking into the facts of what is wetlands, or what are wetlands, maybe I should be saying, before we give the rezoning? After we give the rezoning, the car, what do you say, the horse is bolted?
Yeah.
The barn door's open,
Wow.
It's already done. So driving here tonight on 90, the amount of pavement, the amount of new builds, the amount of roads, we're driving through the swamp. And I'll just mention this real quick because Al Allen, sometime a few months ago, made this big statement at the end of a county council meeting that this is low country. Now, I don't get offended. I was raised in the north. I don't mind. I actually am not offended by these comments. Just because we live in the low country is not an excuse for building houses underwater. Aberdeen was the biggest nightmare in our side of the county, and it's still half underwater. Why would we continue doing these things when we are learning from previous mistakes? If it's wetlands, we shouldn't be building there. We should be preserving something in the county for future generations. The 2020 comprehensive plan was sent to the state saying we were going to do that. And less than a month after it was sent to the state, it was amended. And one of the things before the Planning Commission tonight is an amendment, again, to the 2040 plan for rezoning of property. Well, we're not preserving anything for the future if every time we have a Planning Commission meeting, we're rezoning something out of conservation and into residential. Why do we need this amount of building is going to be my question for quite a while. We have more building construction going up in this county than probably anywhere in the state. And we keep approving more applications to rezone for residential.
We look forward to Tuesday night. We'll be there with you. We look forward to covering the story as it develops. Please keep us informed as you move forward, okay?
I absolutely will. Thank you very
so
much for your
much.
time.